From No5 Chambers, I'm Richard Kimblin, and this is the Planning Podcast. This week, infrastructure. First up, Angus Walker, Chair of the Board of the National Infrastructure Planning Association, more affectionately known as NIPA, the association that is not Angus. We look firstly at progress with the consenting of infrastructure projects during the emergency. Secondly, we ask whether consenting procedures might actually be better after the emergency. And lastly, we turn to infrastructure and the economic recovery. We mention a case known as Drax, a case with a mix of net zero, a DCO, and a late letter to the Secretary of State. Hugh Richards, Planning and Environmental Barrister at No5 Chambers, takes us through the facts, the issues, and the practical points arising. Angus, hello, how are you?
I'm very well, thank you. How are you?
Yeah, really good. Very good of you to be here with us. We're going to have a look at infrastructure matters more generally, but we're going to also try and focus in on three key topics, being how we're going to progress infrastructure matters during the course of this pandemic, then turn to the question of how we make things better than when we started. Very positive approach there, and looking at reforms in the context of the recovery, which we evidently need. Angus, do you think that we can make any progress with infrastructure projects during the course of the emergency?
Yes, we can, and indeed we are. There are a number of stages to these projects, and each of them has its challenges because of the inability to assemble or visit things, to inspect documents, visit places. Probably the biggest challenge, I would say, is the environmental assessment stage of surveying a potential site for a project, because if you're doing a traffic survey or air quality or monitoring or something, you will get much lower figures than usual, which will be unrepresentative, and therefore if you add your project on top, it'll look better than it really is as far as the impact is concerned. And no amount of changes to the law or practice can really do anything about that. So that's probably the main challenge.
Right.
However, there are even ways around that. Before the pandemic was even a twinkle in anyone's nose, there was a concept of worst case assumptions if you can't get onto land. An example is HS2, which obviously is a very long route, and the chances of getting on every parcel of land to measure it was pretty remote. But what they did was assume that the most number of species that might be present are present, and that sort of thing, and then propose mitigation accordingly, which may not ever be needed, but at least it's available if things are as bad as possible.
Right, but that's really interesting, isn't it, in terms of both practice and the law? And I suppose in terms of practice, downside, you've also got real concerns about people working together in their normal fashion and getting onto land and people being comfortable with you being there. But being slightly more glass half full, the regulations and the directive have only ever required you to undertake the assessment that's reasonable in the circumstances. And I imagine one would argue that you take the data which you can obtain and make the reasonable assessment on the basis of that data, and that should be good enough.
I think it should be, although there are a couple of caveats. If you haven't even started your data gathering, then if you've got nothing at all, then perhaps that is a bit of a showstopper. But if you've got most of it, or there are previous studies that you can sort of pro rata up to the current situation or something, then it may be possible. Second caveat is, I think there are certain types of land that are particularly sensitive, like Natura 2000 sites, i.e. habitats and appropriate assessment and all that, where rather than environmental assessment being a balancing act compared with the benefits of a project, this is more of an absolute threshold that you have to overcome. I think if you didn't have any data at all on habitats, you'd be struggling. So, and air quality is another one where it's an absolute threshold rather than a relative balance. So with those caveats, I think you should be able to proceed in most cases.
And most cases need therefore to turn to each individually and understand what the potential risks to the project are further down the line.
Yes. Well, I imagine that ecology surveys will actually produce results that are higher than normal if all the creatures have re-colonised land that people aren't visiting very much. But on the whole, readings will be lower.
And what view would you have if ultimately you came to an issue-specific hearing and it said to you, well, this is pandemic data, go back and start again?
Well, you might get that challenge, particularly from someone who doesn't like the project on principle, and there is inevitably someone on every project in that situation. But I think the government, at least, certainly wants projects to progress, and it's in the interests of the national economy to progress somehow. So decision makers and examiners would be trying to find a way to keep these projects going. So at least you'd have that positive tailwind, but there may be some insurmountable, maybe projects where there's so little data that you can't really call your environmental statement an environmental statement because it's got too many holes in it. Got more holes than cheese.
Well, your caution resonates with me as somebody who persuaded an examiner that red kite were not going to be significantly affected.
Is this in the Mynyd the Gwent area in Wales?
Absolutely. But Amber Rudd took an entirely different view, as she did of all of the Mid-Wales schemes. Whether that was coincidental, I can't possibly say. But one can see difficulties ahead if somebody takes against data.
Well, indeed. One just needs to have a robust story that compensates for the lack of data in some way. And actually that leads into the other issues around these projects, which is the lack of ability to move around. For example, document inspection. The regulations do require that when you're consulting and when you're inviting representations, i.e. objections to your project, you have to have physical documents available, but that is obviously a problem at the moment because most of the usual venues like libraries are closed. And perhaps even if you did manage to deposit the document somewhere, nobody will be able to go and look at them anyway. So I think that is an area where a change in the law is needed, although the Planning Inspectorate has tolerated online-only document inspection so far. But then I think they're taking a risk as well as applicants for allowing that, because somebody could come along and challenge it and say, I wasn't able to read the documents and I can't look at them online or whatever. So I would prefer there to be a change in the law, and that has happened in other areas. For example, for local authority meetings, documents were required to be physically deposited, and the law has been changed to say that online only counts as making them available. So it's not impossible, and I hope it happens soon. The other issue is not being able to congregate. So when you're doing your consultation, you can't have live events, which is traditional. There's nothing in the law, this time at least, that requires you to have them. You're supposed to issue a statement of community consultation, consult the local authorities on whether they think it's adequate, and it doesn't say what you have to have in it. You don't need to agree it with the local authorities, but as long as they're reasonably comfortable with what you're proposing instead, you should be allowed to go ahead.
Can I that's a really interesting point. And looking ahead, taking account of the way in which we approach these things, I just wonder whether some years hence, whether the objection might ultimately be that somebody fails to make consultation events available online, and that there is in fact a criticism from that point of view. I do wonder whether the current changes and the acceleration that we're seeing will bring around, in fact, the reverse expectation, not the expectation that there will be a physical event, but the expectation that one will be able to participate from the dining room table.
Well, that was an interesting point, and one which I think we will visit in the Ending Up in a better place than we started section that's coming up.
Okay, let's do that.
Yes.
Let's do that.
Yes. So the other physical congregation is hearings, but the Planning Inspectorate has now conducted 2 weeks of hearings on 2 different projects, one of which we're acting, which is Junction 10 of the M25 at Wisley. And they had hearings this week, compulsory acquisition hearings, online using Microsoft Teams. And although I wasn't present, even virtually, I understand they went very well. So that is promising. I think when it comes to consultations, though, when you can't do one thing physically, you'll need to compensate or even overcompensate in other ways so that the standard of reach of people and the quality of what they are able to understand about the project is equalled or exceeded compared to traditional methods.
Now, Angus, may I ask you, in respect of the Wisley event, if I was simply an interested person who wished to observe rather than participate actively, would I have been able to do that in the same way that I could pitch up and sit at the back and watch a hearing, inquiry, or issue-specific hearing?
Well, not exactly the same way, because, of course, when it's a physical hearing and it's advertised, you can turn up without anyone expecting you because you can find out about it independently. Whereas for these virtual ones, when it's on Microsoft Teams, you need that link that allows you to click in and participate. So you do need to at least inform the Planning Inspectorate that you would like to attend. That is a slight difference, but
okay.
As far as I know, they let anyone who wants to do so and provide them with a link. I think they practiced in the weeks coming up to the last couple of weeks, where they took on roles of awkward people who were trying to monopolise the proceedings and things like that, or maybe shout obscenities, who knows. So the inspectors were able to cut people off and control the hearing.
I see the advantage of the mute button.
Yes, indeed. And I think Zoom certainly allows you to kick people out. I presume Teams does as well. I think the biggest issue actually was the display of documents, because often in hearings you want to all be looking at a land plan or something. And when it's done virtually and it's a complicated PDF, everyone's sort of sitting there while it draws all these layers over a few minutes, well, a few seconds anyway. And that is a bit of a problem. So I think Planning Inspectorate are going to issue standards for having simpler documents that don't take a long time to display. That's one learning issue. The other one, actually, which isn't to do with the Planning Inspectorate at all, is that the promoter's team the applicant's team will be all in different places, and they need a separate way of communicating amongst themselves to the official hearing method. I think on the Wisley project they were using WhatsApp, although that's not a video method. But that is something you need to set up and practice if you are, not just the applicant, but if you are any sort of team who's spread out before you attend a hearing.
That is an interesting point, isn't it? The need to have 2 open channels of communication, one essentially private,
yes,
and one essentially the hearing. So it sounds to me, Angus, as though you're positive on being able to progress infrastructure projects during the course of the pandemic.
I am indeed. I think it's perfectly possible. As I say, I think the biggest issue is probably the site survey issue, but even then there are ways to overcome it in most cases. So yes, I hope things can keep going. They will probably be slower because consultation periods will probably have to be a bit longer because people take longer to access the documents or learn about the project or whatever, and longer to respond. Hearings at the Planning Inspectorate whereas this week's compulsory acquisition hearings, they would normally have just been a single day. I think they were spread over 3 days in short sort of 90-minute bursts. So again, those are more spread out. And I think there are plans for preliminary meetings, which are the meetings that kick off the 6-month examination. They normally take half a day, but they will be spread over a few days as well.
I see, spreading it out. So on the status quo, you say positive, we can carry on, we can achieve things, that's good. But do you go further? Do you think that as a result of the reflection that we've been able to engage in because of the time available during the lockdown, etc., do you think that we can get to a place which is better than where we started?
Well, I am an optimist, so yes, I think we can. I've got a couple of examples. So the hearings, if they're online, it does allow people who wouldn't normally get to a physical venue to participate in a hearing. As an example, I acted for Esso. They're building a replacement pipeline that goes all the way from Southampton to London, 92 kilometres, I think. And all the hearings were held roughly at the midpoint of the pipeline in Farnborough. And yet, if you lived in Southampton, it would be quite difficult, even if you were able-bodied and had your own car and all sorts of things that many people don't, you would have difficulty attending a hearing. But if it was online, you could. So I think we may end up with a sort of hybrid of consultation events and hearings where there are virtual people and physical people attending. Probably a bit of a nightmare to organise, but I don't see why it can't be done.
Well, if I may say so, I completely agree with you. And the term hybrid is exactly it. I completed a trial this week, which was exactly that. And the approach was just as you say. We picked out the bits of the evidence which were really important to have people physically present, and other parts of the evidence where we dealt with them virtually. And it really was hybrid, taking account of the needs of the case. And that's your point, particularly there in respect of a linear scheme where you can achieve what physically you could only achieve by moving the hearing along the route.
Oh, yes, indeed.
In an itinerant way. But you've achieved that by doing it virtually. That's what you would argue, isn't it?
Yes, I think that is right. Was your trial, did it swap between virtual and physical, or was it both at the same time?
It oscillated. Witness A, virtual, witness B, physically present because it was necessary for that person to be seen. So that's exactly what happened.
Yes. The second area I think could be improved. We could end up better than before is notifying people about forthcoming projects for the purposes of consultation. Obviously, this is having to be done virtually. The traditional method is, and still required method, is placing classified notices in certain publications that are local to an area. But I really don't think anyone, or hardly anyone, reads those. And even if they did read them, they probably are the sort of people who know about the project already. So I'm not sure that it reaches any new people whatsoever.
So we can make it better. Any other ways to make it better?
I've got one more suggestion, which is the thorny topic of environmental impact assessment.
Indeed.
Inevitably, environmental statements for these projects are absolutely enormous and run to several volumes. And if you are a member of the public, particularly if you're one who doesn't know their way around an environmental statement, it can be daunting to the point of being completely off-putting to try and work out what the impact is on you from this multi-volume mammoth work. Whereas an online environmental statement, my dream, although I don't really dream about environmental statements, would be that you could type in your postcode or something and it would just tell you what the impacts are on that location in terms of all the different topics of noise and air quality and so on. It could tell you what mitigation is proposed to reduce the baseline impacts. It would be much easier to navigate for a member of the public.
Well, that's a fascinating area, isn't it? The area of plan tech and the way in which one can assess using GIS and then presents information in a way. I guess it presents an opportunity, doesn't it? If the assessment is favourable, you can present that material in a way which is easily accessible and demonstrates acceptability.
Yes. Of course, if it's not favourable, the traditional environmental statement is quite a good way of hiding residual impact, if you ask me.
Now, Angus, do you think that any of what we've been discussing can result in us kick-starting the economy and contributing to the recovery?
Well, probably these small, rather procedural changes wouldn't make much impact to the economy as a whole, apart from the continuation of projects that would otherwise stall if they weren't able to continue. Actually, that's quite an important reason. So yes, as long the fact that they can continue itself contributes to not only reducing the depth of the bottom of the recession, but also increases the speed at which recovery is possible. But there are wider reforms that are being discussed. Infrastructure is often one of the first areas that the government looks at, because it itself, just by putting money into it, authorising it and building it, does have a beneficial effect on the rest of the economy, because if it's transport infrastructure, that means you can, not only is building it provide jobs, but once it's there, that provides greater access from people to places of work and so on.
Well, I can recall from the last recession that the approach was all of a sudden to fund the improvements to the A46, which previously were not enthusiastically supported. But as soon as the recession hit, A46 was funded.
Well, that's an interesting one element of getting out of the recession. It probably wasn't the single contributor to the economic recovery.
The A46 probably didn't get us out of the last recession, but
no, on its own, but it contributed.
But you think that supporting infrastructure, including linear infrastructure, is going to be something which will be a policy objective?
Well, I think it's not just transport infrastructure, but I think energy is very important. And I'm not sure if you are following or even involved in the challenges to the energy national policy statements. There are 6 of them that were produced in 2011, which set the need for different kinds of electricity generation and other infrastructure. So they're coming up to 9 years old next month. And at the moment, the way they're written, they are completely neutral on the type of technology being used to generate electricity. So a coal-fired power station is just as good as a wind farm, according to the national policy statements. And that is clearly way out of step with what current thinking is.
And would also be out of step with the NPPF. If you look at planning policy statements subsequent to the national policy statements, they don't really add up, do they?
Well, no, they don't. I mean, I think they're desperately out of date, and the lengths that the government are having to go to in granting decisions on development consent orders are getting more and more tortuous. And this was years before net zero came in, and so it doesn't have any regard to that. Although the 80% reduction from 1990 levels was enforced, the Climate Change Act actually came in. It was given royal assent on the same day as the Planning Act 2008. But I think they need to not be technology neutral, and they need to be more directed at fulfilling net zero. I mean, we are potentially on the verge of a revolution in energy infrastructure, and the government really need to encourage that. And at the moment, these policy statements certainly do not do that.
So is this fair, that the current status and datedness of the national policy statements is an inhibitor? It is holding back that which may well be possible.
I think it's not only holding back that which may be possible, but almost encouraging things which ought not to be advisable. So an example is, well, I wasn't involved in this, but the Drax gas-fired power station.
Yeah.
On the plus side, it is replacing a coal-fired power station. But on the minus side, it itself is producing, has the potential to produce a huge amount of emissions, something like 10% of the country's emissions, even when there was an 80% reduction from 1990 levels, never mind 100% reduction. That was challenged in the High Court, but was allowed to proceed. I don't know if it's being appealed. But it's a clear example of the national policy statement being out of step with current thinking.
So not only is the potential to move on hindered, in fact, in some respects, the datedness of the policy statements is taking us backwards.
In a way, or at least not moving us forwards. I think the government do have a genuine problem that if they declare them to be being reviewed, even if they don't suspend them, that'll immediately have an impact on current projects that are being developed, because that'll create policy uncertainty. And it is that fear that is probably stopping them grasping the nettle and going ahead with reviewing them. Interestingly, the government's response to the legal challenge to these national policy statements being out of date says, we will wait until the energy white paper is coming out, and that could be another year, and then we will decide whether to review the national policy statements. No commitment to actually do so, even then. So that could be the middle of next year, by which case they'll be having their 10th birthdays, these national policy statements. So that is somewhat depressing, but I think that's the reason for it.
So we reached the conclusion of our 3 topic areas. To what extent is NIPA promoting these topic areas? Is NIPA active on them, or has NIPA been slowed down too by the pandemic?
No, indeed, NIPA has actually been very active. So that's the National Infrastructure Planning Association, for anyone who doesn't know what that stands for. It's also the name of a restaurant in London, which sometimes Google searches show up in preference to this organisation.
Well, one's shut and one's still active. Yeah.
Yes, indeed. The infrastructure one is very much active, and we have been liaising very closely with both the Planning Inspectorate and the Ministry of Housing, Communities and Local Government on how to progress NSIPs, that's nationally significant infrastructure projects, during the pandemic. And we're beginning to think about coming out of the pandemic and helping to improve the regime to help to kickstart the economy as well. So we wrote quite a long paper that covered all the different aspects of projects that I mentioned earlier and how they might be got round. So, for example, we have recommended that the law is changed on physical document deposit. So I still hope that's coming. And we are thinking about how to improve the regime as well, so we end up better than we were before. So it's been actually much more active than it was before during the pandemic.
Okay, well, what we will do is we'll make sure that associated with this podcast, we provide the link to that document for anybody who wants to follow it up.
Yes, indeed. And I produced a short summary of it that's more geared towards applicants. It's only 4 pages. The original document is something like 26 pages. So for those who...
So that's the NTS, is it?
Yes, I think so. We're also having a series of monthly webinars that we're going to launch next month, the first one next month, dealing with all these different topics. Your listeners will be welcome to tune into.
And I, for one, will definitely be participating because they sound like they are going to be the sorts of things which help us with all 3 of those topics that we've been covering off, which are all going to make a big difference. I look forward to seeing you on the webinar, or on at least some of them. Everybody who's listening, I'm sure, will be very grateful to you for all of those top tips and insights. So thank you very much indeed.
You're very welcome. Thank you for inviting me.
Now, Hugh, help me with this. During the course of conversation with Angus Walker, he mentioned the Drax case. What is that about?
Well, the Drax case, which delights under the name of the Queen on the application of Client Earth against the Secretary of State for Business, Energy and Industrial Strategy, judgment was given on the 22nd of May of this year, and it was a High Court challenge by statutory judicial review to the Secretary of State's decision to grant Drax a development consent order for the construction and operation of 2 gas-fired generating units at an existing coal-fired power station site in Yorkshire.
Now, Client Earth, as I understand it, were dissatisfied with the approach in respect of greenhouse gas emissions and the policy which relates to them.
Yes, Client Earth ineffectively won the argument in front of the examining panel. And the panel recommended that the consent order should not be granted. But the Secretary of State decided to disagree with the panel and granted the order. And so Client Earth went to the High Court to try and have the Secretary of State's decision quashed. The challenge was unsuccessful, largely because the panel itself had made an error, which the Secretary of State declined to follow. And the panel had misinterpreted national policy on the assessment of need for the development. And the High Court found, Mr. Justice Holgate, that the Secretary of State had been entitled to conclude that the need for the development outweighed the substantial adverse environmental impacts.
Right. So the examining panel being told they'd got it wrong, Secretary of State taking an approach which the court found to be one that was properly open to it. This was in large measure arising out of net zero changes to the 2008 Act. Is that it?
Yes, although in fact the Secretary of State and the panel both concluded that there would be substantial adverse impacts, environmental impacts, arising out of greenhouse gas emissions, and they both gave substantial weight to that fact in the planning balance. But what the Secretary of State said was, I think that the need for the development should be given substantial weight, as the energy NPS provided for, and therefore the planning balance, as she weighed it, indicated a grant of consent. Now, the difference between Client Earth and the panel on one hand, and the Secretary of State and Drax on the other hand, was over this matter of need, because what the panel said was that the energy policy statement established a qualitative need for gas-fired power generation in this case, but that Drax should be required to show that there was a quantitative need for the development that they were proposing. And the panel, on that basis, found that Drax had not shown such a quantitative need, and therefore, in the planning balance, the environmental impacts held sway and recommended the consent order be refused. The Secretary of State, with whom the court agreed, said no, both qualitative and quantitative need are taken as a given on the proper interpretation of the energy NPS. And on that basis, the Secretary of State had explained, or had no need to explain, why she took a different view to the panel on the weight to be given on the plus side of the planning balance, so far as Drax were concerned, and that the overall balance that she arrived at was open to her.
Well, there we are. That's a fairly unusual set of circumstances, isn't it? Having regard to the way in which DCOs normally go, a recommendation to refuse a DCO is quite unusual from an examining panel, but then Secretary of State reversing it, and lawfully so.
Yes, it was. And we were all used to, in the Section 78 appeal system, to inspectors recommending a grant of planning permission and the Secretary of State disagreeing with the inspector and deciding to refuse planning permission. And then the arguments that can arise in court thereafter. Well, has the Secretary of State given adequate reasons for disagreeing with the inspector? A similar sort of argument was run in this case, but Mr. Justice Holgate said, no, there was no need to give any more reasons than were given, because the Secretary of State made it clear that the reason that she was disagreeing was not over, in particular, matters of planning judgment and weight, but it was principally over the interpretation of the policy. Interestingly, after the close of the examination, the promoter had written a letter to the Secretary of State, perch a direct contact with the Secretary of State in other interesting cases. Anyway, but that letter had not been copied to the other participants in the examination. But it turned out that the letter had only got as far as officials, and the letter had not been seen by the Secretary of State herself, and the advice given by the officials had not been influenced by the letter, and therefore the court said that there had been no prejudice because the claimant had not lost an opportunity to advance a case which could have determined the outcome of the application.
Well, in that regard, Hugh, I think that it would be helpful, wouldn't it, if we put on the website a written summary. Do you think we can do that?
Yep, no, very happy to do that.
Okay, good. And so, Hugh, in terms of practical significance, what would you say the key points for listeners to take away would be?
Well, I think there are 4 practical takeaway points, Richard. The first, and perhaps most obviously, is the importance of interpreting policy correctly. And we know that interpreting policy is a matter of law, so get your lawyers on the case is the first practical lesson. The second is a reminder of what ought to be a hoary old chestnut, in that matters of weight in planning judgments are for the decision taker. Thirdly, if something is really important to your objection, you've got to make sure it becomes a principal controversial issue. So my advice would be to give the decision taker a list in your closing submissions or in your written material of what you regard as being the principal controversial issues. And then you've got something to show the court if later you want to complain about the reasoning on any matter. And then lastly, in order to succeed on a fairness challenge, you need to show some prejudice. And that is almost always fact specific.
Hugh, thank you very much indeed. That's helped everybody get through what is a fairly substantial case. Thank you for the note. Thank you for taking us through it. Stay safe.
Yeah, and you, Richard, and goodbye to everybody.
That was the Planning Podcast from No5 Chambers. Coming up on the Planning Podcast will be reform of the planning system. And we will be tempting you to ask, what next for our cities? Till then, goodbye.